stated. Mr. Prislenik never said anything about the lawyers who talked about the defense. The defense has said as follows: we're trying to win at all costs. We only care about winning, not
Didn't I
justice.
sustain that objection?
No, you did not until the fourth time I asked it, Your Honor. I objected 4 times. Let me continue. We suborned perjury, stated 3 times. I objected each time. We could have called the worst of them all. We could have called Haji. The court knows we found out about him that morning. The court made a finding that their discovery violation was not inadvertent. That means it was intentional. That means it was not accidental. They got up here and just told this jury that they didn't hear from this witness Haji, that we could have called him. The court knows we have a hearing about it. It's been very clear. The court found that they were not honest in what they provided. They were not honest about when they actually turned the information over. And now he's up here and able to argue that. And when I object, basically I'm told it's overruled. I mean, Judge, the problem is the court made these findings. The court said you could not disparage lawyers. Let's be clear. Anything that he had said was true. That we suborn perjury. That we don't care about justice. Those are reportable issues to the state bar. The court knows it's not true. I know you know it's not true, Your Honor. I assume he knows it's not true. And then finally, he has repeatedly misstated the standard of reasonable doubt. There is no standard whatsoever where you can say that each one of these are, quote, reasonable doubts. That is not a correct standard. The standard is looking at all the evidence in total. Did the people prove the case beyond a reasonable doubt? It is improper to say, if this fact is wrong, that is, quote, a reasonable doubt. You can argue that that evidence is important enough, etc. So they're misstating the reasonable doubt. But more than that, Your Honor, they're disobeying the court's order about disparaging other lawyers. I object. The court lets it go. Then
No, wait a minute. I don't let it go. If I see or I think that Mr. Tacopina is disparaging you or you are disparaging him, I will put a stop to it.
Judge, I objected 4 times. You overruled all my objections. You finally sustained an objection. And when the court sustained the objection, I made clear that my issue was the second part of it, which had to do with they were in essence disparaging both of us. Your Honor, I mean, it's not a hard question. They're saying we suborned perjury 3 times. Your Honor, that's improper. It's misconduct.
I didn't hear that.
Your Honor, it's in the record. 3 different times he said we suborned perjury. I don't know what to tell you.
Hold on, Kathy. Was that said?
I don't remember.
Your Honor, we said,
All right.
said 3
If
different times.
it was said, then I should have stopped it. But I don't remember if it was said. You have made so far 9 objections, 6 were overruled, 3 were sustained.
The problem
So
was,
therefore, what?
the problem was, I believe the first 5 I made were all overruled. The court, Your Honor, I've been in front of this court for 30 years. The court knows who I am. The court knows what my ethics are. I'm not going to sit here and tell the court that I'm objecting when he didn't say it. He said repeatedly, we suborn perjury. Your Honor, that statement in and of itself is severe misconduct.
All right, can you, in the break, can you state, if that was said, then I'll bring it to the attention of the jury. That's an improper statement.
This is what I'm asking. Mr. Tacopina can go after our witnesses all he wants. He can even misstate the evidence. What he cannot do is he cannot argue, A, why we put a witness up there. He cannot say that we suborn perjury. He cannot say that all we care about is winning. He cannot say that this is supposed to be the pursuit of justice and the prosecution doesn't care about that. He has said all of those things. He needs to stick to the evidence in the case. Either he doesn't know California law or doesn't care. And Your Honor, the court's already found, and the worst of them, and I want the court to instruct, he got out there and argued, why didn't you hear from Haji? The court knows, Your Honor, the court made a finding.
You're repeating yourself.
Well, will the court do something about it? Will the court instruct that that was improper argument?
All right.
Can I respond?
No.
Okay.
That's failure to call logical witnesses is permissible. You're going to have a rebuttal argument. You can address it in your rebuttal argument as to why you didn't call it.
Your Honor, with this all I'm asking, Your Honor, and I'll say it. The court knows what happened. We've had many hearings on this, et cetera. They knew the evidence, they presented it late, they had repeated orders to turn over statements. He got up and said, that's not the statement of the witness. 1054-3 is very clear. What they gave us is supposed to be the statement of the witness. And when he's standing up saying, well, that's not his statement, that was his statement, that's what they had to turn over. So yeah, I can go back and I can go and argue in the court and say, well, it's just both sides are arguing, but Your Honor, there are rules for a reason, and we follow them. You have not found one instance in this case, not one, where the people did not comply with discovery, where the people did anything unethical. You've already found, you used the words, it was not inadvertent. Non-inadvertent, Your Honor, means they lied and they intentionally did not give us.
I don't agree with that. That's not, doesn't mean he lied.
Your Honor, non-inadvertent.
Don't argue with me. I don't think it means he lied. I just said it was not inadvertent. That's the extent of my finding. It was not inadvertent. I'm not going to debate with you whether they were or were not lying. I don't believe it was a lie. I want to give the court reporter a break, and we'll take a break until 3. Wait.
I'll give for, I have to just respond to a few things, but there's a record here. One thing, I don't want to upset the court, so we can do it.
You're not going to upset me.
No, I'll be quick, I don't want to get further into it, I'm sorry. But there were some things that were said that were just wrong. First of all, they called our witnesses liars in their summation. So I'm calling their witnesses a liar, which he admitted to being, by the way. So, I mean, if our witnesses are lying, and I put them up there, obviously, they're saying we came up with this Tottenham story. So they're saying, I object, as they say, I'm supporting her. That's what they're saying, number one. Number two, I can't say that they want to win at all costs. That's not, I can't say that. I don't think that's an improper argument. If you say it is, I won't say it again. But the other thing, Your Honor, I didn't argue that that wasn't a statement. I said it's not a sworn statement of 12B, and it's not a recorded statement. I said it's a summary. I'm accurate in describing it. It is a summary. I'm just going through what I said. You know, they disparaged our entire defense, mocked it. So I'm giving them a little bit back. I don't think I'm doing something.
You want to interrupt him? He didn't interrupt you?
You know, and the thing that he said though, first of all, I disagree. I think one fact of relevance would be a reasonable doubt. The jury finds he's incredible on one thing of importance, like the shell casings. That's a reasonable doubt. If they so choose, it's up to them to decide what a reasonable doubt is. That could cause them to find not guilty. That's up to them. But it certainly is an argument that can be made. They can say, no, it's not a reasonable doubt. But I can make that
It's
argument.
fair comment.
I know.
It's fair.
But the last thing, I think Mr. Lewin's hearing failed for a second. Because the one thing, because I know he said he has an issue with it, the one thing I never said was they could have called Haji. I wouldn't do that. I didn't say that. They could check the record. What I said was they spoke to him that morning. They had a recording of Haji. That was brought out to Lululemon. I said, if Lululemon was inconsistent with Haji, we would have heard the tape. I didn't say they could have called Haji. If I can show you where I said that, I would never have said that. We could have called Haji. He wasn't going to come. So I never said that. I just simply said what was on the record.
If it was said, Mr. Lewin can address it tomorrow. If it wasn't said,
It wasn't.
then there's nothing to address. All right, we're off the record. I want to give Kathy a break. So can you find?
Yes.
I asked Kathy, the court reporter, to check her notes, and she's able to do that. And there is an indirect reference, it's not even clear, to Relly and embracing perjury. So far, Kathy has not found the word suborn. Embracing perjury, I don't even know what that means, but from here on out, if any counsel wants to state that a witness committed perjury, that's fair game. But I do not want either directly or indirectly any counsel accusing the other one of suborning perjury, encouraging perjury, touching on perjury. I don't want the word counsel and perjury being used together.
Turning a blind eye?
What?
Turning a blind eye?
Hopefully they'll
Right.
It's improper. It's not only untrue, it's improper.
Yeah, and stay away from that, they're only, they're winning at all costs. Well, it's fair comment on the evidence.
Because they can say about the evidence, they cannot say prosecution is, all they care about is winning their case. All they don't care about justice, that there's authority that says that is.
Yeah, no, that's.
The judge,
Stay away from that.
you don't believe it's true.
No, I don't,
So
and I know it's not.
See,
All right, so stay away from what the prosecution's motives are. Talk about the witnesses, don't talk about the prosecution's motive. And when Mr. Lewin speaks, you're not to talk about the motives of Mr. Tacopina or Mr. Siegel.
Joe, you're free, you're free to comment on, hey, they didn't call this witness, et cetera, just not that extra step.
All right,
Well, my explanation will be much shorter now.
what's that?
My explanation will be much shorter now, so.
Like that. Okay, we're gonna start at 9:00.
Okay, folks, so I think we left off when I was discussing with you all the whole notion of the person who used to be Relly is not Relly anymore, apparently, who came back at 11:09 to the scene to retrieve shell casings. Now, again, his story changed. Ultimately, he said it wasn't him, so some mystery man showed up at the scene at 11:09 apparently. But one of two things happened here. Either that really was Relly, like you first said on the video, coming back at 11:09, staying for 2 minutes, returned to the scene, and he lied, of course, then about being there with his girlfriend, if that was him, and about taking photos of the shell casings while there, because those photos weren't taken until 11:45. Or the prosecution has absolutely no evidence whatsoever that he ever returned to the scene, ever. Whichever one you choose, the prosecution has no evidence at all that Relly actually recovered those shell casings from the scene. You could have called his girlfriend, Miss Parker, to back up his claim. Yes. She's probably busy doing what she does, but she didn't show up. Their burden, corroborated with witnesses, meaning the word of Relly, I think, is fair to question. There are a lot of things in this case that are going to be easy to corroborate of his word, if they're true. I'm going to show you a little list. Those sort of cool I put together, but not yet. But there is no corroboration, and they couldn't. Lydia Parker could come in here and say, yes, I went back with him. We found 2 shell cases. She's still his girlfriend, apparently. No evidence whatsoever that he took the shell casing off the scene. While on that point, by the way, the photos taken with Relly's iPhone of the alleged shell casing, allegedly taken at the scene, but not until 11:45, an hour and a half afterwards, they had time date stamps on them. But what you didn't see from the prosecution was the GPS location data for those digital photos on Relly's phone. Why? I mean, they didn't show you, what else they didn't show you was GPS location data from Relly's iPhone to show you where Relly was on November 6, 2021. That would solve a lot of mysteries here. It's not like they couldn't have done it. GPS location data from Relly's iPhone, which they had. That would have answered all the questions. Could have corroborated it or not. After all, you heard that law enforcement, in this case, went out of their way to get a search warrant to obtain GPS location data for ASAP Ill's iPhone, just to show that he was, one, near Selma Avenue and Vista Del Mar about 10:12 p.m. on November 6th. It showed that in his location data. And he was near Rocky's residence at 11:11 p.m. that night. That from Detective Flores' testimony, lest there be any confusion. The question was asked, and specifically, it's important because it showed they could have gotten GPS location data from their only witness who's not corroborated, and whose word may be a little shaky. And specifically, the T-Mobile information law enforcement obtained authorized to search Ills, Elijah Ulunger's, ASAP Ills, his call detail records, and his GPS location. Detective Flores is correct. And the GPS location data, I should say, answer yes, okay? And those records, the GPS location data that you all were able to obtain showed that Elijah Ulunger, ASAP Ills' cell phone was near Selma Avenue and Vista Del Mar at approximately 10:12 p.m. on November 6th. Answer, I believe that's correct. Question, those records also show that Ills, I'm just going to refer to this Mr. Ills for the purpose of moving this thing along a little bit. ASAP Ills' cell phone was near Mr. Mayor's residence at 11:11 p.m. later that night. Answer, yes. Subsequently after, yes. Well, what that shows you is that not only had they had the ability to do that, they in fact did it. But why just for Ills? Why not for Relly, who claims he came back and found shell casings? That would have put an end to this mystery. Was he there? Was he with his girlfriend? Was he not there? You heard again. There was no dispute, by the way, about Ills that he was at Selma, Vista Del Mar and Selma that night during the incident. You see him on video. And rather than looking to see where Ills was at 11:11 p.m., why didn't they use Relly's GPS data to show you where he was at 11:11 p.m.? Was that him? Was that not him? Did he ever go back at 11:45? This would have answered all your questions, either corroborated the story or not. Would have put the lie to it again. It would have also shown you where those iPhone photos of the shell casings were taken. Instead, you have to take his word for it. You just have to take his word for it. Yes, they could have done it. They did it with Ills for some reason, but not for Relly. So just take his word for it. If the word of any witness ever deserved to be tested in this case, it's Relly. I mean, it's a man whose tongue is a stranger to the truth. And they could have easily corroborated his story or shown that his story was not truthful. They just didn't do it. I want to pause here so this really sinks in. Detective Flores told you that he wouldn't want anyone other than the police taking evidence from the scene because that could hamper and hinder an investigation. This is obviously fairly important. As a detective, I asked him, you'd agree when conducting an investigation of an alleged shooting, you wouldn't want anyone who's not law enforcement removing evidence or taking evidence from the scene, right? Answer, correct. Because that could hamper and hinder your investigation. Answer, it can. And that makes sense, because once evidence is contaminated, once an alleged crime scene is contaminated, there's no way to undo that, no way. You never get a second chance at it. If you want reliable information from a scene, it cannot be tampered with, it cannot be staged. If it's staged, it's useless. It's pointless to review it, because whatever you see, you have to reject it. You have to. And that's exactly what Relly says he did here. And that's why it was even more important for the detectives to test his word by looking to corroborate it, but they never did that. To be clear, the prosecution just wants you to take Relly's word that he found shell casings at the scene. That's it, just take his word. After all, they presented to you nothing to corroborate it when they easily could have. And just ask yourselves, if Lydia Parker, Mr. Relly's girlfriend, could readily corroborate his claim, don't you take the word heard from her? The fact is, Relly didn't want her anywhere near the courtroom. Anywhere near the courtroom. Remember when I showed him a picture of Miss Parker, his girlfriend? And I said, is that your girlfriend? He said, I don't know. little disturbed by that photo, but anyway, back to more important things. What he just said was, I don't know if that's my girlfriend. I'm just, anything he tells the truth about, I don't know if that's my girlfriend. That's not, I don't know, that's either yes or no. He couldn't recognize his girlfriend, and at one point he said, oh, because she had makeup on. I mean, we're not talking about clown makeup, right? I mean, she literally said, my girlfriend. Why lie about that? Aside from his name, I don't even know if that's really his name. Did he not lie about anything in this case? I mean, you know that wasn't truthful testimony. He didn't want the only person who could or couldn't corroborate his story to be anywhere near this courtroom. That's neither did they. The judge told you, the defense does not have the burden to do anything in this case. They do. They had the burden. We don't have to prove anything. We didn't have to introduce a single piece of evidence. We didn't have to produce a witness. That's because the laws of the United States and the Constitution demand that. But as a matter of fact, we had more substantive witnesses in this case testified than the prosecution did. We wanted to give you the complete picture, all the evidence, because we want you to know the truth. And there's nothing to hide. Rocky did not commit a crime, not by a long shot. Why? Again, I need the answer as to why they didn't show you the GPS records of Morelli, when it could have shown where he actually went after the incident. From the incident, where did he go for that hour and a half? And where did he take those pictures from? That would have been important, especially if there's any question that that video may not have been shown to Morelli returning. If that wasn't him returning to the scene at 11:09, 11:11. So where was he really at that time? Unfortunately, we don't ever get to know the answer, because they didn't get his GPS location information. We're just supposed to accept his word that he didn't go somewhere else to get showcased. So we just have to accept it. And the judge gave you instructions on this about the credibility of witnesses, and it's in your agreement, take it back with you there. But it says that a witness lies to you on an important fact of the case or in his testimony. You can feel free to disregard the entire testimony of that witness, or you can just disregard that one fact and believe the rest. But he lied to you about so many crucial things. I'm not talking about his inconsistencies. Again, we'd be here until the summer. He lied to you about the most crucial facts in this case. You know, by the way, this is not someone who's uncomfortable around guns. You heard he owns a 9mm, he posted those pictures on the Instagram. His 9mm sticking out of his waist, he said. You heard he owns 9mm semi-automatic. We've never seen proof or he actually obtained it. Second, he blatantly lied about his access to 9mm shell casings in Los Angeles. That's another account of perjury. And that was a big one. And we have to talk about this. We have to spend a little time on this one because what happened there was very crucial. He lied about having access to 9mm shell casings 2 weeks before the incident on November 6th. He lied to them. He lied about being in Los Angeles. He lied about having access to shell casings. He lied about shooting. I'm going to show it to you. This next episode is not even one lie or one perjury. It was like a perjury miniseries. This next one. It was unbelievable. One lie piled onto the next one, onto the next one. You got caught with that, then he went to another. It was really a glorious training. And you're gonna see it. I mean, I asked him first if he fired a 9mm weapon before November 6, 2021. Sort of an important fact. Because we need to have access to 9mm shell casings. First he said, no, absolutely not. Then I wanted to make sure, I wanted to almost help him give me the truthful answer. I said, well, how about at a shooting range a few weeks before November 6th? Did you fire a 9mm at a shooting range? Right, hit them off on November 6th, 2021. He said, definitely not. And I repeat, I said, definitely not? And he got all belligerent with me, he says, you heard me, definitely not. I didn't even own a firearm, he said. I only got my firearm license a year and a half later. Listen.
Let's move closer to the time of the incident on November 6th of 2021. A few weeks before November 6th, 2021. And a few weeks before, you testified that you found shell cases at the scene. Found the shell casing. You fired 9mm weapons at a shooting range, correct?
Definitely not.
Definitely not.
You heard me, definitely not. I didn't have a firearm. Only got my firearm license a year and a half later.
So, you heard me, I think this, you did not like me, clearly. Because I asked you to confirm that answer, you heard me, what are you asking me, you heard me, definitely not. I didn't even own a firearm, I only got my firearm license a year and a half later. Lies, 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 lies. And that's when we all saw the video of Mr. Efron firing a 9mm semi-automatic weapon on October 19, 2021, 2 weeks before the incident on November 6th. And I pointed out to Mr. Efron, I said, what you just told this jury was that before November 6, 2021, you didn't fire any guns because you didn't have your license. And then he said, no, unless I was at a shooting range. And I said to him, sir, I just asked you, were you at a shooting range? And you said, definitely not. And I asked you again, and you said, you heard me, definitely not. He just made stuff up as he went along. Look at this.
Mr. Efron, you just told the jury, I don't know what I'm doing, 316, 319, 5 days out of the year. Well, I'm telling you, what you just told this jury was that before November 6, 2021, you didn't fire any guns. Because you didn't have your license.
It was just last I went to a shooting range.
I mean, you just saw his testimony, which was about 1.5 minutes earlier, where I said, was that a shooting range at least? Maybe he did that? Definitely not. Twice definitely not. And then explain why it was definitely not, because he didn't even have his firearms license or whatever. When he got busted with the video that he didn't think anyone had, because it was not brought out on his direct, of course, I said, unless I was at a shooting range. He just thinks he can make that up in front of you. Like, he just told you definitely not at a shooting range, and then just in front of you, like, I don't know, guys. I mean, there has to be a point in time where you have to be so offended by him just looking at you guys and lying. He's took an oath. An oath. You know what oath means? Absolutely nothing to him. Absolutely nothing. He didn't say that. That was blatant perjury right there. He witnessed another count of blatant perjury. But what happened in his courtroom after that, I think made it worse. After, you're gonna see it, what happened. Because this was now all about, okay, so now we got him firing a gun. Don't say that yet, please. We have him firing a gun before November 6, 2021. We have him firing a 9mm. He lied about it repeatedly. And then, so after securing the date of the 9mm firing of October 19, 2021, I tried to ascertain the location of the shooting range. And the prosecution then asked for a stipulation. You're gonna hear it. That the shooting range was taken outside of California. And the witness all of a sudden adopted that. Let's look at this.
And where is it? And where is it? Visitation is open to it. So we have a situation on that date. On that date, this is outside of California.
There was this stipulation, but at the time, I believe all parties in good faith believed that the shooting range was was outside of California. No one is at fault, it's what the parties believed at that time.
Well, I didn't believe anything, so I didn't know. I'm not saying anyone's a fault, I'm just showing how it's played out with the witness. He put on the witness.
Right.
How we got.
The prosecution asked for a stipulation based on what has happened so far up until this point. They believed in good faith that it was outside California. The fact that it wasn't came as a surprise, I believe everybody. But
Well, except the witness, which I don't argue.
everybody at council table.
Yeah, not believing everyone counts it, I just want
Right.
to, just let this play out. How we
New
got.
Jersey or something like that, or like, you know, so I don't guess, it's not.
Same objectives, improper argument, that's.
I explained to the jury, go ahead.
New Jersey or something like that, or like, you know, so I don't guess, it's not.
Next line. Last line was stop Los Angeles, or not LA. So anyway, the witness then said, at the hearing, whatever we heard in the court, in the banter, he then said, well, maybe it was probably New Jersey, something like that, but it's not LA. I knew that, for sure, he knew that. So, understand what just happened there. The witness, all of a sudden, after lying about all those things we just went through, and I don't repeat them again, then heard argument and said, oh, but it's not LA, it's maybe New Jersey. Because being in LA, that would have been a problem. But something happened over the weekend, little problem for Mr. Earl. See, on Sunday, between 2 p.m., and he was on Friday, that was on Friday. On Sunday, between 2 p.m. and 11 p.m., someone on Twitter posted a screenshot that you still heard about, of a video showing Relly at the shooting range that was played before you, alongside a picture of the Los Angeles Gun Club. Locations right there. It was the same. Relly was tagged on that, everyone was tagged. So what does Relly do? Sometime between 2 o'clock and 2:50 that same day, immediately, he calls the prosecution and said, oh, I checked my Instagram account and I realized I was in Los Angeles on November 19, 2021. And I realized I was at a shooting range. And what's the reason the prosecution elicited from Relly as to why he made that discovery? Well, he was going back to check his Instagram account on whether the shooting range was in Los Angeles because he wanted to correct any mistakes he made. So it's true. Just like you say it straight, but that's literally what he said to you. He really was concerned about making a mistake, so he wanted to make sure he checked his Instagram account to see if he made any mistakes. First of all, I asked him, see, your Instagram account doesn't have anything about gun range. And he starts saying, that's not my Instagram account. Well, aren't you really boss? Yeah, but, okay. Okay, folks. I guess he didn't go bother checking all his other so-called mistakes that he made. Just that one that happened to have a post busting him at 2 o'clock. Within minutes, he calls the prosecutor. He was tagged on the post. Within minutes, he called the prosecutor. What a coincidence. You know, what about all the other mistakes? What executives did you meet at Capitol Records and Universal Records that you no longer can meet because of what happened here? You couldn't mention the name of anyone he met with, but he said they were on his phone. He could check his phone. Oh, there you go. He was checking his phone to correct the record here. That didn't happen. How about the Miami property, Mr. Relly, that you invested in? I mean, last year, it was only last year, sir. You invested in Miami property. You posted on your Instagram. I asked him, which property in Miami did you invest in? I don't remember which property. Lie. I mean, no one invests in property doesn't remember which property. Unless you're a gazillionaire, and that doesn't matter. And he's not. And then I asked him, well, how much did you invest in the property? I don't remember. He didn't go back and check that. So remember that just remember that one, how that all played out here. When considering his credibility. Relly told you, just that, there's so many things, the Miami robbery thing, that was just nonsense. But this was horrific. You got caught lying. It's, maybe New Jersey, definitely not LA. I went back and checked, it's definitely LA. That's clear perjury. So you know he didn't check his Instagram account, wanted to correct a mistake about whether the shooting range was in LA. That wasn't truthful testimony. You've seen him testify in the courtroom. The witness who told you, when he said definitely not, he was committing perjury, because that was his then answer. He cleared that up. I'm gonna show you this in a second. When he said definitely not to me, I questioned him. I said, you said definitely not. Because then he got busted with the Twitter thing. And he said, well, yeah, I just made that up because I didn't want to answer any of my questions, any of your questions anymore. He literally said to you, he just lied under oath on a very important fact, like whether he had access to 9 million showcases, because he was tired of answering my questions. I just know I do.
Brought this one on this topic, it's rare, just a few minutes ago. Okay. Okay, yes, I did. Okay, you said yes? Yes. Did you look like you were confused by that question at all when you said definitely not? And to be honest, I just wanted to start talking to you.
So you look like you were confused by that question because he said he was confused by that all of a sudden now. When you said definitely not, I didn't shoot a 9 millimeter at a shooting range before November 6th, definitely not. So you look like you're confused, then she goes, to be honest, oh, here we go. There's a watershed moment. To be honest with you, I just want to stop working with you, so I just said, Jesus. Just give me my 30 million and let's get this over with. He just told him to perjure himself. But you should believe him without corroboration. We all know it wasn't a mere coincidence that minutes after that post that he was tagged on, he told the DA. He called because he knew what was coming the next day on Monday morning. He knew what was coming. And that's the prosecution wanting to correct that mistake. I'll hold that. Let me move on. But again, that is not a minor fact in this case. That's not a minor fact. It's not a game. This is life. Whether their so-called victim, Tyrell Efron, had access to 9 millimeter shell casings just a few weeks before he claims to have found 2 9 millimeter shell casings in Los Angeles. Yes, he did, in the same city. He had access in the same city. Here's the funny thing about facts. Because facts weren't getting in his way. But the funny thing about facts is this, as John Adams once said, it's one of my favorite quotes. John Adams said, facts are stubborn things, and whatever may be our wishes or our inclinations, or the dictates of our passions, they cannot alter the state of facts and evidence. And you cannot alter the state of facts and evidence, no matter what Relly tells you, no matter how you want to interpret this testimony, no matter what they say to you. So with this evidence, ask yourselves, ladies and gentlemen, did Relly first lie to you about going to a shooting range where he had access to 9 millimeter shell casings, and then lie to you again about having access to those 9 millimeter shell casings here in Los Angeles? I mean, why would he do that? Why would he lie about those two things? There'd be no reason for him to lie about that unless it was to cover up something about those 9 millimeter shell casings he claims he recovered. No reason to lie about that. You know exactly what happened, why he lied about it. As the police found when they got there was no shell casings there because he had a prop gun. He had a prop gun, as unimpeached witnesses told you. And he claims that he got these shell casings from the scene an hour and whatever later, a half later. And then he held them for 2 days, gave them to the police 2 days later when his extortion attempts failed. One thing's clear, the prosecution has not proven beyond reasonable doubt that Relly did not get those shell casings from somewhere other than the scene. They did not prove that beyond a reasonable doubt. That's enough. That's enough. Beyond the fact that Relly had access to shell casings in Los Angeles now that we know, which he lied about, the prosecution presented no evidence, zero evidence whatsoever trying to corroborate Relly's claim that he actually found those shell casings at the scene. None. Not Lydia Parker, not GPS location data, stuff that would have done it pretty quickly, pretty easy. Not a video. Relly first said that it was fake. When I showed him that video, it was fake. He didn't think anyone knew we had those videos of him at a firing range. By the way, we're not like master investigators. They were just on his phone. We just looked at every single thing on his phone. They had it too. They gave it to us. We didn't hear about that on his direct testimony. Would have been something to bring out to deal with. That wasn't brought out. If we didn't cross-examine, we never would have known he was in Los Angeles 2 weeks before. 9 of those shell casings popping back into his head as he's firing. And he lied about it, perjured himself. There's only one reason he will lie about that. Cover it up. Heard about the magazine. I'm gonna get that magazine. The Block 43, Mr. Chris Long spent a lot of time on it today. And there was no effort made to test. Now, you heard the judge, he instructed you that 2 weeks, I think it's 3 weeks ago now, he instructed there'll be no testing on that. 3 weeks ago, right after the trial started, 3 weeks ago, no testing. Here, going forward, great. That's January 2025. What about 2021, 2022? Well, not 2021, because they recovered in 2022, let me be fair. 2022, 2023, 2024. 3 years they had to take that magazine that they recovered and test it to the bullets recovered. They didn't do that. They spent their efforts having a ballistics expert come in, show you a very nice PowerPoint presentation, which in the end proved only that the shell casings possibly, there's that word again, possibly came from an aftermarket slide for a firearm frame that could possibly have been compatible with the Glock 43, or not possibly. I mean, literally, that was the import of that testimony. Possibly could have come from an aftermarket slide for a firearm frame that could have possibly, this is his testimony, possibly been compatible with the Glock 43 magazine, or possibly not. That was the ballistics expert's testimony. Possibly or possibly not is definitely not proof beyond a reasonable doubt. In any event, Lou Levin told you that the Glock 43 magazine was his. He explained why it was his. Whether they want to mock him, mock his answer, he was in Rocky's house after they planned to go to a shooting range. He told you he had bought it, he owned the Glock 42. And magazines are stored all next to each other, 42s, 43s, and all that stuff. Lou told you. I don't know anything about this stuff, personally. But he went to the store to buy accessories. He mistakenly read a Glock 43 magazine because they're all different models of Glock. The magazines are all stored together, he told you. He told you he didn't realize it until he tried to load it at Rocky's house in preparation for going to a shooting range. And then when his .380 caliber Glock 42 ammunition didn't fit, he tried 9mm ammunition from his Smith & Wesson, which he did, from his testimony. And of course, that magazine didn't fit any of his firearms. He left it at Rocky's house. Why? Why not return it? He told you. It was over an hour away where he purchased the thing. It would have cost more in gas than the $20 it cost him for that magazine. But one thing you know, despite all the questions from the prosecution, Mr. Lewin, they did absolutely nothing to refute or contradict his testimony. Absolutely nothing. This was true. I mean, at one point, he told you that magazine was never used. He told you it was never used. You can take this back, you have all the evidence with you. But the reason he told you it was never used, he's got a picture that he looked at it. There's not a scratch on this thing. It's a piece of plastic. It's a cheap piece of plastic. That's why it costs $20. He told you it was never used because if you put this into a steel gun, a Glock, this is gonna scratch.
There's no evidence to support that.
Oh, weapon, this is pure. It's virgin, as Levin said. There's no scratches on this thing. It's brand new. And they had 3 years to test it. 3 years to test this. They didn't do it. Not only did they not connect really shell casings to the magazine in Rocky's house, they didn't connect those shell casings to Rocky himself. And that's important. You heard that law enforcement submitted those shell casings for fingerprint analysis and found absolutely none on there. And I asked the detective Flores if you could find fingerprints on a piece of metal, right? And pretty easily he said yes. So they submitted Rocky's fingerprints for fingerprint analysis against the shell casings, and they found none. So they tried to make excuses for that. That's another fact that's not good. So they tried to make excuses, like, have on the bullets. The show is once recovered. Claimed to be recovered at the scene by weather at 11:45 with no GPS data. Anyway. They claim, Victor Flores said, yes, you do get fingerprints. My fingerprints are all over this thing right now. Okay? He said, yes, you'll get fingerprints on a shell casing, metal, it's empty, it's portion. But then they said, well, could there be a reason why you wouldn't get fingerprints? And he said, yeah, there could be. That's one that was, yes, rain, water, cars, and even wind. Imagine that. Maybe wind wiped the fingerprints off the shell case. Imagine. So now my fingerprints are on this thing. Oh, there goes my fingerprints. Are you kidding me? Wind? Wind knocked the fingerprint off the shell case. That's an excuse. It's not a fact. There was one other explanation by Detective Flores that makes a lot more sense. He said, well, human contamination, like someone wiping fingerprints off shell casings, that could do it. And you know that after those shell casings were, yes. Alex, now where am I? All right, hold on. Human contamination, that's right. Human contamination. The detective said that human contamination, like someone wiping fingerprints off a shell casing, that could do it. And you know that after those shell casings were fired, the only person with an incentive to wipe them clean would have been Relevant before he gave them to the police. Just like he wiped his phone clean of threatening messages to Rocky. We'll get to that. They didn't bring that out, we have to. So Ruddy wants you to believe his fingerprints weren't on them because he supposedly went to Dunkin' Donuts to get a bag to pick them up with. And you know that's not true. There's no Dunkin' Donuts open at 11 p.m. at night, especially during COVID.
Objection suspended. Objection suspended.
Well, you decide if that testimony is correct.
There's no testimony, Mr.
No,
Ms.
It's
Sampson,
sustained about when Dunkin' Donuts are open until.
That's
The
not.
jury's job is to decide the credibility of the witnesses, including all testimony that is given by that witness.
So here's what the witness said, and it's your job to decide. Bang. He said, I went to Dunkin' Donuts at 11 o'clock at night, got a paper bag from Dunkin' Donuts at 11 o'clock at night in Hollywood. And that's the bag I used to put the bullets in that had no fingerprints on it. You determine the credibility of that statement. He came in here and told you that. You also heard that law enforcement took Rocky's DNA. They actually took his DNA, despite Detective Flores saying that DNA was necessary as part of their investigation. You had to swear that to a judge. They never compared it to the shell casings, or even the magazine recovered in Rocky's house. That might help. They didn't do that. For that matter, you know that Relly's 9mm shell casings were different than the 9mm shell cartridges found in that magazine. You've seen that picture a few times. Completely different brands. The ones in the Relly said he found were Federal cartridge. Lululemon's cartridges were made by Sig Sauer. Completely different. Again, on that point, you heard the magazine was never used, was fully loaded, meaning 2 cartridges were not missing from it, but they were different bullets anyway, so it doesn't matter. Lest there be any question that that Glock magazine in Rocky's house was not the magazine seen in the video on November 6, 2021. All you have to do is look with your own eyes. All you have to do is look with your own eyes. So after this part, I think we can stop it, but let me just go through this last name. The Glock magazine seen in the video is different. The Glock magazine recovered, which we just showed you actually, is a Glock 43 and it's black. Black, that's the magazine. The magazine that you're going to see in Rocky's prop gun on November 6th was not black. It was extended, as Lou Levin told you, to look more intimidating, because it was a little thing, Glock. And if you look at it, you're going to see what it was. But don't forget, 12 and Lou both said, and the prosecution sort of mocked this somehow in their summation, they said, oh, conveniently, they both identified the belt and the extended magazine. So they both could identify, you know, the thing. They conveniently came up with these 2 different things to be able to say it was the same prop gun. Not conveniently. Look at the picture. That's what it was. Lou put it together and Colby saw it. That's the magazine in the, okay, I know what we're doing here now. Thank you, Ken. That's the, we'll use that point again in our arm.
Yeah, you see on the screen.
Put that's too hard on the screen.
Yeah.
Sorry. I was pushing to it. Did everyone see here? No, okay. Anyway. That's the magazine recovered. Here's the prop gun. I'm gonna try and do this where. How about now, we good? All right. That little thing at the end is the belt clip. That's a clip. And that's what Lou Levin described. Here's what you see. This thing, this clear, silvery looking thing, is the extended magazine that Lou Levin described, that 12B described. It's part of this Glock prop gun, and it's an extended magazine. So it makes this thing look bigger, and they both described it as clear. This is the first time, because if you play this in real time, you'll never see that thing. We stopped it. And so here is the magazine, the extended magazine, to make this thing look bigger, and it's clear. It's not that. It's clear. Okay.
Right now.
Yeah,
All right, folks.
All right.
We'll resume at 9 tomorrow. Mr. Zona? All right, see you all tomorrow.